Kathryn Campbell from Canada. She just tells me she's been having a period of study in Cambridge, so she's come here today from there. Kathryn is Professor of Criminology at the University of Ottawa. She has degrees in Psychology and Criminology from McGill and Cambridge and University of Montreal. And her research interests include young persons in the law, miscarriages of justice, upon which she's written a book on miscarriages of justice in Canada, Indigenous justice issues and animal law. And she's faculty director of the Innocence Ottowa project, a student-run Innocence project. And she's going to talk to us today on extradition law in Canada. So, Kathryn, the floor is yours. Welcome.
Thank you very much, Ian. And I can't see with these. First of all, I want to thank Caroline and Mary for inviting me to come and speak here today. It's wonderful to get to visit Oxford. I'm just going to put my timer on because I don't want to go too long. And I've never been here before, even though I did study at Cambridge, and it's a beautiful place. I'm really impressed with how beautiful it is here. So today I wanted to talk about extradition law, and as I was saying before, the choice of words doesn't actually come from me. Of injustice, but extradition lawyer calls how extradition law is manifest in Canada, although as it seems to me a word I've been hearing all the past 10 days about what's going on in your political situation. Hopefully now it'll be a little more stable, but I think it's a good word. Now, I just want to start by telling you how I came to study this area, because it's not something that I've really looked at before the past year, I would say. My research is mainly in the area of wrongful conviction and miscarriages of justice, and it's been more traditional research, I think, where I've looked at contributing factors and evidentiary aspects of how police and courts make errors and wrongful convictions can result. I also, as I published a book on causes and responses, and I have another edited book coming out this summer with some Israeli colleagues, actually, about international perspectives on miscarriages of justice. Now, as Ian said, I do run an Innocence project, and I'm sure you're familiar with what that is, and we help wrongly convicted try to overturn their convictions. And I met a man in 2018 named Hassan Diab, and he is a Canadian sociologist. He was a professor at University of Ottawa. And he was wrongly, in my view, wrongly extradited to France in 2014 because he was a suspect in the bombing of a Paris synagogue in 1980. He came to our annual general meeting at Innocence Ottawa, and every year we have somebody come and talk about their experiences. And he'd only been released from France 2 months before that, and he really was a mess, actually. And he talked to us about what had happened to him, and I was really struck at that point by the injustice of his experience, and given there was little to no evidence, and I'm going to show you the evidence that they used against him. And but what's frightening about his case is the French Court of Appeal in 2021 has decided to bring charges against him. So they dismissed all the charges in 2018. He was released, and now they want him to come to France in April to be tried. And I think I was baffled by that, and also by that sort of led me to look at extradition law within the framework of it being a miscarriage of justice in terms of how it's applied at times. And in my first paper that I presented in Glasgow 2 weeks ago, I talked about Hassan's case in great detail, and I called that the irrelevance of guilt or innocence in extradition proceedings. And in this paper that it's still ongoing, what I want to talk to you about today is it's a study of surrender decisions. So, and I'll also show you where that fits into the process. And I'm looking at the role of assurances and what that role plays in the process of extradition. So my abstract, I think for me, certainly the application of the law is highly problematic. It's been referred to as the least fair law in Canada. That's by an extradition scholar. And it's also been referred to as the Shambles of injustice, which is Hassan's lawyer actually calls it that. And since it was enacted in 1999, our Extradition Act has never been reviewed. And that's almost 25 years. So I think it's ripe for that. And research has shown that in this fight against transnational crime, and in the spirit of comedy, the Canadian government rarely refuses a request for extradition. There's a joke amongst extradition lawyers that the only question that you need to ask your client is, do you want a window or an aisle seat on the plane back to the country that you've been required to go back to. The objective of the paper is really to look at how the law and practice of extradition law in Canada can be understood as representing a form of miscarriages of justice. And what's seen is research by people like Botting and Robert Curry has sort of demonstrated that at the committal stage, the evidence in the record of the case, which is the document that has to be presented in order for the extradition to go ahead, is it's accepted without question, and in some cases it fails to, and in many cases it fails to allow for the introduction of any exculpatory evidence on the part of the person who saw it. Now, the focus of this paper, though, is more on the surrender stage that follows the committal hearing, where the minister has to decide if he or she is going to surrender that person to the requesting state. In most cases, they actually do. It's meant to be it's a discretionary practice. It's a decision that the minister has to make, and it's very political, as we'll see. And in recent years, the Supreme Court has established that it won't extradite someone to a foreign state where the death penalty is a consideration, but it doesn't have to. It can decide not to, and we'll talk about that. And I think there's other considerations as well that have an impact on surrender decisions that also deserve further scrutiny. So extradition, and if you want to ask questions throughout, I have no problem with that. There's no general duty under customary international law to extradite someone. A country, I don't think Israel extradites anybody, neither does France. So it's not, there's no duty to do so. But I think in what's happened over time is governments have created, treaties and diplomatic relationships whereby, through policies, regulations, and laws, they support each other in combating transnational crime. And really, extradition itself involves the formal rendition of a criminal or alleged criminal from a state that has custody to a state that wishes to either prosecute the fugitive or someone who's already been convicted, and they want to impose a penal sentence and that's the requesting state. Now, modern day extradition serves a number of objectives, and I think what it does, because it's so easy to cross national boundaries now, what extradition law does, it allows for the investigation, prosecution, and suppression of crime committed by fugitives from justice. But it is a complex matter. It's not a simple application of one particular type of law. And what we see is an intersection of treaty law, international public law, and criminal law. And some would say that actually that criminal law standards really don't apply until somebody is extradited, and I think that's probably true. And but the offense that people are extradited for is often criminal in nature. It's not for speeding or dangerous driving. It's for serious crime generally, because I think the expense and in Canada, certainly in many of in our Extradition Act, you have to have committed an offense that would garner a penalty of 2 years or more, I believe it is. Now, it's also governed by the Extradition Act, but our Charter of Rights and Freedoms, which is something I think is a very important protection of individual rights in Canada, and as well as, and in terms of extradition, the Mutual Legal Assistance in Criminal Matters Act that allows our crowns to act on behalf of requesting states in terms of seeking out information. And what I think, though, is that human rights also, while the human rights interest in protecting individuals in this process is somewhat limited at times, and I'll talk about that more. Now, the process of extradition itself, it engages both the judiciary and the executive branches of government. So the first step involves the Minister of Justice. And here we see, although much of the work is judicial, ultimately the start and the finish of the process is with the Minister of Justice. So here the minister is asked to issue authority to proceed, and he or she may do that if they're satisfied that a number of criteria established. The person is who they're seeking, the alleged offense, it has an equivalent, it's called double criminality, is an equivalent Canadian offense, and the process is similar to laying an information or an indictment that would happen in domestic criminal proceedings. And it's sometimes thought to be really more an administrative law process at that point, but it's not really, but it is the least contested of the steps. The committal second step is more problematic, and it's held before a superior court, the Court of Justice. And the objective is for the sitting judge to consider the evidence, but in a limited manner. So like a preliminary hearing that we would have, but it's not a mini trial. So there's no back and forth at all, and there's not really any sharing of information. What has to happen is the disclosure of a prima facie case against that individual. And what else can I say? There has to be evidence that the crime occurred in Canada, and it would justify committal for a trial. Now, the record of the case is the document that contains a summary of the evidence, and a lot of extradition lawyers say that what's contained in that is really hearsay, unsworn statements, and unsubstantiated evidence. So there's really not a huge need for a lot of, I would say, solid evidence to be contained in the record of the case. And there just has to be some evidence linking the accused person to the crime. And that's where a lot of issues, I think, come into play, because it's a very modest screening advice. And what has happened, now if the person wants to introduce evidence, it's a very high threshold for them to do that, the sought person to challenge. Exculpatory evidence is not allowed at all, apparently. And the prosecution, they have to demonstrate that the prosecution's evidence is manifestly unreliable. So then they need to show sort of fundamental inadequacies in the Crown's case against them. So, and what's even, I think, more problematic is that case law has established that a judge can't deny a committal, even in cases where it's weak or unlikely to succeed at trial. It just seems that it's almost like if a country asks for a citizen to be extradited, Canada sort of goes, okay, when do you want them? That's been my experience in the research that I've been doing. Okay, so as long as the evidence in the ROC is reasonable, that a properly instructed jury could come to a guilty verdict with, it's supposed to be allowable. And also, too, the argument is that because we need expediency in these matters, because, all of the, the different countries that are involved, that you can't have a more thorough weighing of the evidence at that stage. Now, the surrender stage is the one that I'm more interested in right now. And here we see the discretion goes to the minister on whether or not to surrender that individual to the requesting state. And his decision, his or her, it's a man now, his decision is guided by political and charter considerations. Now, decisions made at the committal hearing can be appealed, but decisions here can also undergo judicial review. And the minister is not meant to assess the evidence at this stage either, but in exceptional circumstances, he or she can do that in making their decision. Now, in terms of the actual process, there are certain limits on these surrender decisions and this is in the law. So it's not completely discretionary. So the minister must refuse, because there's no choice there, to order surrender when it would be unjust or oppressive, although that's pretty, it's hard to determine what exactly that means, or if it's made for an improper purpose, or if it's discriminatory, if it's statute barred, or if it's a political offense or one of a political character. But they're, sorry, I skipped one. That's limited because that would exclude terrorism. So that still be a judge can, sorry, a minister can extradite in cases like that. And if it's not an offense under criminal law. Now, where there's more discretion, which is surprising, I guess, because before I started looking at this, I thought this was more something where they must extradite. They must refuse to extradite, and so they can't. There's some discretion around whether if the individual is subject to the death penalty, and in the requesting state, if there's double jeopardy protection, so they can't be tried twice for the same thing. If the conviction occurred in absentia, and if the person was a young offender, and or if the criminal proceedings if the offence, is subject to criminal proceedings in Canada, or the conduct didn't even occur in Canada. So those are kind of situations where those considerations would in some way limit that discretion. Now, charter protections affect decision-making in this, and so there's a human rights appraisal in the whole process as well. In particular, Section 6 of our charter basically says that Canadians have the right to remain and live in Canada, but if they're extradited, well, then that's not a protected right, but it's considered a reasonable limitation, so that's not really affected. And Section 7 is basically is the right to life, liberty, and right to life, liberty, and security of the person. And that right is always seems to be a consideration in extradition proceedings. But what we see tends to happen is that this whole idea of non-inquiry, where we don't really go in and sort of say, okay, well, what kind of condition is that person going to face in the country they're extradited to? It doesn't really apply in the same way, because it's thought that the charter is replacing that inquiry, and these agreements that our government makes with other countries in these treaties, those considerations will already have been addressed. But you'll see in some cases I'll tell you about that, it doesn't really, it doesn't always apply in the same way. We see, though, that the administration law in some ways limits the impact of a human rights inquiry. It seems to trump the human rights inquiry in some cases. Now, it's my belief, I think shared by many, that it's a very political process. The requests are rarely refused. Just for example, and the thing about it too, I have to say, is that it's impossible to find out the information on the Canadian steps taken by the minister around any kind of surrender and committal decisions. The only way to know about it is if they're challenged, and then you'll see a court of appeal. If it's a reported case, then you'll see them discussing what was said in a committal hearing or in a decision that a minister makes a surrender. So it's really hard to get information. So there's big gaps. It's very random. And I've made an access to information request, but I haven't heard back yet. Just to give you an example, sometimes they'll throw out one statistic here and there, the government, so you can find out, but 90% of the extradition cases heard by, that come from heard in Canada are initiated by the Minister of Justice in response to requests made by the United States. So it's, we have such a big border, there's a lot of back and forth. Now, we talked about this earlier, the case of Meng Wanzhou. I think that's not a typical case, but it really does reflect the political nature of extradition proceedings. If you do know about it, then hopefully I'm not telling you anything you don't know, but she was a Chinese citizen and chairman of Huawei, and in 2018 she was questioned and later arrested by the RCMP upon her arrival in Vancouver Airport, and based on a provisional extradition request for fraud and conspiracy to commit fraud in order to circumvent U.S. sanctions against Iran. But the U.S. made a mistake there, because we don't have sanctions against Iran. So there was no double criminality. So we couldn't really hold her. So what happened? They couldn't hold her. So what happened then is they changed it to charges of trade secret stuff. So they were able to hold on to her. But really, this was a trade war issue. So a very lengthy and complicated extradition proceeding followed, this accusation made on both sides. And in September 2021, they reached a deal. The U.S. Department of Justice reached a deal with her to resolve her case by deferring criminal charges and withdrawing their extradition request. She entered into a deferred prosecution agreement with them, and all the charges were dropped. So she agreed to a statement of facts that she'd made false claims about Huawei's relationship with Skycom, which operates in Iran, and that there was some support of Huawei's work in Iran. So that was in violation of the U.S. law, but she wasn't fined and she wasn't charged with any of that. She was on house arrest in an unbelievable mansion in Vancouver's Point Grey area. It wasn't so bad. She had one of those bracelets on her ankle, and but this strained relationships with Canada and China, because just shortly following her detention, they charged two Canadians who were working in China, Michael Spavor and Michael Kovrig, with espionage, and allowed them only limited access to consular services. And they were also held for over 1,000 days, but not in a mansion in Vancouver. and they were released just following her release as well. And it's really, I think, they were considered political retaliation for Meng's arrest, but the Chinese government said, oh no, that wasn't it. But they really, all of them, I think, the three of them became victims of a trade war between the US and China. And this extradition proceedings became a mechanism for that. Now, some of the difficulties I just want to briefly talk about have to do with at the committal stage, because Canada doesn't really refuse very many of its extradition requests. It seems to be really a rubber stamping function by on the part of the judge in the hearing. That is problematic, and some lawyers say, well, that allows the Crown to make allegations without proving them, and it prevents the defendant from relying on evidence to challenge those allegations. It's a bit of a catch-22 situation. But it's hard to know really what types and how many cases are refused or screened out by the International Assistance Group, which is the group of lawyers who work for the minister on extradition, but they represent the interests of the countries that are seeking the individual. Now, also, you can't, and the committal judge is now allowed to sort of engage in a limited weighing of evidence. It's from a case called Ferras. And even though this was the side of the Supreme Court, that doesn't seem to have translated into actual action at the committal stage. Also, and in terms of surrender, problems at that stage have to do with a lack of transparency. The information is not available. Public information should be. I mean, it's not. You know, I'm sure they can talk about, yes, I guess, privilege and the fact that this information is protected in some cases, but none of it is really revealed at all. And but what I want to do, so there's a lack of transparency, and the great discretion that the minister has, I think, is problematic, as well as the standard of review. There's deference made to the Minister of Justice in these matters, given the relationships, the international relationships that we have with other countries. So and the standard of review is one of reasonableness and not correctness, and I think that also causes some problems in terms of administrative law. So I want to talk now about the case of Hassan Diab, because I think it really illustrates a lot of the problems with this law. And this is a picture of the bombing in 1980 that happened in France, and it was an anti-Semitic attack because it was a synagogue. It killed 4 people and wounded 46 people. The bomber used an alias, Alexandre Panandriou, and the reason why the police know that is because the bombs were in a scooter that was parked outside the synagogue, and the scooter was in his name, and they found a hotel card that he wrote on that was used as evidence against Hassan, and I'll show you that in a second. So nothing happened for quite a while, many years, but France was still pushing at this in the background. There was some evidence of this person named Hassan that might have been involved, and then finally in 1999, the French authorities received intelligence information from an unnamed source that pointed to a man named Hassan Diab. And when Hassan Diab came to our University of Ottawa to talk about what happened to him, he said, by the way, that's a very common name in Lebanon. The Minister of Education is called Hassan Diab. And he said there were over 30 people that he knew at the university that were called Hassan Diab, and who was originally from Beirut. And so they developed a theory about what had happened. Now, 27 years following the bombing, the French press claimed that the authorities were investigating the suspect living in Canada. And the way Hassan found out about it was he was giving a lecture at University of Ottawa, and there was a reporter in the back, and he was from a French newspaper, and he wanted to talk to him after, and he told him. So that's how he found out they were looking into him. Now, a very complex and lengthy process of what happened around his extradition. He was arrested in 2008. The authority to proceed was, and he had to wear an ankle monitor as well that he had to pay $2,000 a month for. The authority to proceed was issued in 2009. He was extradited in 2012. Now, the record of the case, and he was extradited in 2014 because he went through all the appeals and judicial review processes, and he was put in French jail, 22 hours a day for 3 years, and he was never charged. So they extradited him just to get him over there. Now, the record of the case in his, and I'll talk to you about this in a second, was unusual because you think about how long ago that this crime happened, right? And there was newspaper reports in it, there was traditional evidence, there was intelligence, but the case was initially based on fingerprint evidence and handwriting evidence. And the justice at the committal hearing said the only evidence that tipped the scale in favor of committal was this handwriting evidence on this hotel card. Oops, oh, I didn't mean to do that.
Nice.
Okay. Is that all right?
Can you zoom out a bit more?
There,
Yeah.
okay, sorry. It's very sensitive. So as I said, he was freed and came home in 2018. Now, I think what occurred in Hassan's case and is continuing to occur illustrates how extradition law is fundamentally problematic. And I've been I guess a miscarriages of justice scholar for a long time, and a lot of that scholarship looks at sort of wrong man, wrong woman cases where someone's convicted in prison for something they didn't do. And not really, I've never seen anyone talk about extradition law in this context, but I do think this case fits into that. Now, in terms of what happened to Diab, if you think about how do you define a miscarriage of justice, there's lots of ways to do it, but I use Clive Walker's rights-based definition, where a miscarriage of justice is said to occur whenever a suspect, a defendant, or a convict is treated by the state in breach of their rights, and that's whether because of deficient process or the laws that are applied to them, and there's about 7 other criteria as well. And I think in Hassan's case, the extradition law created a miscarriage of justice in his case. The intelligence evidence that was in the application was withdrawn because given the time that had passed, 28 years, this unsourced intelligence that was used was thought to maybe have come from torture. And there was, at his committal hearing, Professor Kent Roach, who I believe was here not that long ago, was testified and said, it could be torture driven, so it would be tainted. And it wasn't used at the committal hearing, but it's still in the file, so they can use it in the trial against him. The fingerprint and palm print evidence, there were 3 specific areas where they found fingerprint evidence, but they knew early on that he wasn't a match, and they didn't tell him, and it became part of the record of the case. And he only found out that later, and that became a part of an abusive process application that he failed on. Now, the handwriting evidence is the most controversial, I think, and the idea was that the bomber was staying in this hotel the bombing was, I think, October 4th, and the 22nd of September, this person was staying in the hotel. Now, you look at that handwriting, okay? I could do that. A child could do that. It seems to me very easy to print like that. I don't find it distinctive. I'm not a handwriting expert, but I think that kind of opinion evidence is problematic anyway. But what was more problematic was the number of experts they had brought to the committal hearing. There were 2 handwriting experts from France that they used who actually looked at handwriting they thought was Hassan's. It was his first wife's handwriting. And so those were thrown out. Then they got a 3rd person who had access to his original handwriting and said there was a strong presumption that he authored these 4 words, Panandreou, Alexander, Lanarka, Cyprus, technician, and a weak presumption that he had authored the date. So that right now, this is the only evidence against him. And it's opinion evidence, and opinion evidence can be challenged. And what's happened now too is since he's been released, and they've got 2 more expert evidence reports, handwriting experts, saying that this is him, and that maybe those first 2 reports were right. Anyway, it's a big mess. Also, Hassan had alibi evidence that showed he wasn't there at the time. He was writing exams in Beirut in 1980 and 1981, and there's multiple witnesses who can support this. There was limited disclosure from the prosecution, as I mentioned. And for eyewitness identification, you know, for all intents and purposes, the bomber was thought to be this Pinandriou guy, but the clerk who signed them into the hotel said he was 45 years old, tall, dark, and Hassan was 26. And there was like so many conflicting descriptions of a number of witnesses at that point. Now, that's him. So he was the dismissal order happened in 2018, and that was overturned in 2021. And France is going ahead with the case against him. They are seeking him for trial in April, and I think it's important to look at it within the context of terrorism in France. It seems to have been one of the European countries that has been most affected by terrorism in recent years, and that may be behind the push to bring Hassan back. It's the only unsolved terrorist case since World War II. I think there's that as well, but I think it's important to solve it, but get the right person, is my view. In terms of guilt or innocence, I do think that from a strictly legal perspective, guilt or innocence are relevant. They're not part of the proceedings. But I think it's hard to see how that could be justified from any perspective that values human rights and ethics, really. So, and maybe because of the expectations throughout the proceedings, guilt or innocence is not really a relevant concern. But if you're the person who feels, and the wrongful conviction scholars in the room know, if you're a person who feels you're being judged for something you didn't do, then I think that's highly problematic. And maybe, you know, a more important question to ask is, you know, can it be relevant, or should it be a consideration in these proceedings? I think human rights concerns also are part of what's gone on with Hassan. He has not had his right to a fair trial within a reasonable time respected, and that's a charter right as well as a right under the UN Covenant on Civil and Political Rights. And some people are even saying we should suspend our extradition treaty with France in terms of how he's been treated. But when he first came back, this is interesting, our Prime Minister said what happened to him should never happen to anyone, it should never happen again. And now that France wants him back, he's not saying anything, so not surprising, I guess. Also, too, the whole idea of comedy, of cooperation and consideration for another country's, wanting to solve a crime that has happened. I think that's part of what it's a broader concern in this case, and also the role of victims. In a civil law country, they have a much more direct role in criminal proceedings than they do in common law countries. So in that sense, I think that's probably been a factor that's affected what's gone on in this case. So I think that sort of illustrates problems, certainly at the committal stage of the proceedings. The surrender, well, I think that was fairly done, but given that all the problems up to committal, it was a difficulty. Now, I just want to talk about the real focus of my research, my current research, which is looking at the surrender decisions. And I find this area of law really interesting because it raises a lot of questions for me about not only miscarriages of justice, but international relations, human rights, public international law, and criminal law. And so I wanted to sort of see how can the minister justify or not the surrender decisions that are made. So once, and I call them problematic cases because I couldn't think of another word, but if anyone can, please tell me. It doesn't really work, but that's sort of what I mean. So the minister is not obligated to surrender an individual to a requesting state. In addition to the power of outright refusal, they can seek assurances. And so that's one way for the minister, and that, you know, they can surrender to any conditions that the minister considers appropriate. And I think that allows the exercise of discretion in another way. And certainly, as I said, it's really hard to know because we really can't find out from the minister what cases or what issues are raised unless they're reported, and they certainly aren't in a lot of cases. So what I found, though, is when I began to look at this issue in my ongoing research, is that the cases seem to reflect difficulties encountered when challenging surrender decisions from either a sentencing or a human rights perspective. So I want to talk to you about a couple of cases in each of those just to illustrate. Now, the death penalty, which I know is a favorite area for you, Carolyn, we haven't had one for a very long time. And I think we've had a bit of a difficult relationship with the death penalty. It was only abolished in 1976, and even up until 1987, there was a free vote in Parliament about reinstating it. And the vote was 148 to 127, so it wasn't as bit closer than I was comfortable with. But certainly, there's been a series of decisions made in the last, within 10 years of each other that sort of reflects our Canadian ambivalence towards the issue. Now, in 1991, there were 2 extradition cases, Kindler and Ng, and they were, they sort of present evidence. They've been described as Canada's historic practice of unconditional extradition. So Kindler had been already convicted and had received the death penalty, and he was in Pennsylvania for some horrific crimes, including murder, and he fled the country and he was arrested in Quebec prior to imposing the death penalty, obviously. And despite a surrender or being ordered by the minister over the extradition request, there were no assurances sought that the death penalty would not be imposed. And at that time, the majority opinion was that it didn't violate this right to life, although I don't know how that could really be stand, but the right against cruel and unusual punishment provisions in the Charter. And also too, and this is where this term is used a lot now, to impose the death penalty by a foreign state for a crime committed in a foreign territory wouldn't shock the conscience of Canadians. Now in Ng, the companion case heard at the same time, he hadn't been convicted or sentenced, but he'd been accused in a number of murders. And when they arrested him for shoplifting, he stabbed a guard, and he had a whole lot of paraphernalia in his car, cyanide capsules, a gun. This was a man who had some ideas about what he was going to do, I don't know. So they sought to extradite him on several counts. And in his case, there was a bit of a hitch in his case because Kindler would have been put in the electric chair, but Ng would have been put in the gas chamber at that time. So there were some concerns about the cruelty aspect of Section 12 of our charter around that. But regardless, they surrendered him without assurances. And in both those cases, the judges talked about the need to defer to governments in their decision to extradite and the danger of Canada becoming a safe haven for these criminals. I have something to say about that. And they distinguished extradition from other practices like torture. That would maybe shock Canadians, but the death penalty wouldn't. That was the idea. Now, the second case, well, third case, I guess, is the Burns and Maffei case, which is famous in popular culture now. There's all kinds of shows about these 2 gentlemen. And they were, and here we see a reversal of the position, the longstanding policy about extraditing to death penalty states without assurances. But for me, it's a really important case because it's the first time our Supreme Court talked about wrongful conviction and how we need to be careful in terms of looking at trying to avoid that. Now, in this case, Burns and Maffei were accused of a triple homicide of Maffei's family in Washington State and crossed the border into Vancouver. They weren't suspected, they weren't fleeing because they weren't under suspicion by the police. Regardless, they were arrested. Now, they challenged the arrest based on their mobility rights, but the Supreme Court unanimously decided that an extradition request to the death penalty had to be accompanied by assurances against imposing the death penalty because it was unconstitutional in all but exceptional cases, and they didn't define what that was. So that really was the framework going forward of this balancing act and on deciding on future cases. I think, as I said, what's significant about this case for me is it changed policy, and they focused on the finality of the death penalty, the lengthy appeals process, how it would exacerbate any traumas an individual would experience on death row. And they even quoted some wrongly convicted Canadians in their decision, Marshall, Milgard, Morin, Soffonow, Parsons, how those cases signaled prudence and caution in a murder case. So, and basically, it's a clear violation of Section 7. Now, the safe haven argument, think about how that would really play out. So an individual would have to have been facing a death penalty, receive a death penalty, escape an American prison, and get over the Canadian, and know about our policy and get over the Canadian border. I don't see that happening. That would be very rare, I think. So I don't really think that's an argument. And the court dismissed it as unrealistic. So that's in terms of sentencing. Now, what we're seeing some more recent cases talk about is sentence length, sentencing disparity around sentence length. Now, that issue it often arises in the context of the United States, which is our most frequent extradition partner. The danger, but there's this idea of extraterritoriality, the problem with that, because are we imposing then our values about crime and punishment on another country? And at the same time, too, you know, I'm sure we're familiar with mass incarceration in the United States, excessively lengthy sentences, life upon life. It boggles the mind a bit. Now, so the surrender issue in this context is that the possible length of the sentence that the individual would face if extradited is more punitive than the one in Canada. In most cases, that is definitely what we see. Now, in the case of Hillis, that was he was a former police officer who was accused of sexually assaulting children in Minnesota. And the sentence he would have faced there was 30 years at one end and 5 years at the other end, whereas in Canada it could have been 90 days to 3 years. So there's an extreme disparity. Horrific crime, no doubt. I'm not saying anything against that, but those kinds of, the minister acknowledged the broad sentencing disparity, but he also said there's no statutory authority that allowed refusal of surrender based on penalties, and that a different sentencing regime wasn't enough to shock the conscience of Canadians. So in that case, he was sentenced in the end to 12 years. And is serving time in a Minnesota jail. He'll be deported when he's done. And the more interesting one, I think, or issue for me, is that life without parole idea, because we don't have that in Canada. We have a life sentence, but it's for murder, first degree, parole eligibility at 25 years. And the idea of sending somebody to a prison for their whole life, I guess their whole life sentence, it raises human rights concerns, but courts don't seem to be very concerned about the disparities, because individuals are extradited now from Canada to the United States for these life without parole sentences. Now, one case that was in 2014 was Mohammed Issa, and he was a Canadian citizen, Iraqi national, who was arrested on a U.S. warrant, and he admitted for a bombing that occurred in Mosul in Iraq, and killed 5 American soldiers. And he admitted his involvement from Canada, where he corresponded with some jihadists, and he gave them some money, he gave them words of encouragement. He gave them $700. He didn't have a huge role, but he had a role. And the US wanted to extradite him, and that was only done if he wouldn't face the death penalty, but he did get a life without parole sentence. He was going to face a life without parole sentence, but what happened was time was passing and the courts in the US didn't want to risk an acquittal, so they accepted a 26-year sentence. So it wasn't life without parole, but it very well could have been. Now, I think that's going to change, and I think that'll be a good thing. And because of a Canadian case of a guy named Bissonnette who killed 6 people at a Quebec City mosque I'm telling you all these horrific stories, sorry, in 2017. And at that time of the murder, he pled guilty to 6 counts of murder, and he received a first-degree life sentence. But the court said, well, the Crown wanted him to have parole eligibility at 150 years, 25 for each victim, and the court agreed to 40. Now, the reason why they were allowed to do that was the Stephen Harper's government in 2011, a conservative government, introduced an omnibus crime bill that allowed consecutive sentences of parole ineligibility rather than concurrent ones. And this Bissonnette's case was the first one to be challenged at the Supreme Court, and the court said that it was antithetic antithetical, to our charter, and that was incompatible with human dignity to take that hope away that somebody would ever get out. And now the minister, I'm wondering now, if given that it's considered unconstitutional, if in future now, if the minister's faced with this, he's going to have to do some juggling around Canada's position on life without parole, similar to the considerations that are given for death penalty cases. So that, to me, might be an interesting thing. I have just a couple more, I think just a couple more cases. How am I doing for time here? Okay. Another sentencing case had to do with Indigenous heritage. And in Canada, we have a sentencing regime for Indigenous people, given their huge overrepresentation in our prisons and jails. 5% of Canadian population is Indigenous, but 25% of federal inmates are Indigenous. And it's kind of like similar to the African Americans in American jails. And 50 to 60, 70% of jail inmates in Western prisons are Indigenous. So we have a 718(2)E, which is part of our criminal code, that basically says a judge has to consider all available sanctions other than imprisonment with particular attention when it's an Indigenous offender. It's not a get out of jail free card at all, and people are held to certainly a high standard, but it is a consideration. So these two men, Leonard and Gianne, were up on drug charges in the States with lengthy sentences as well as the fact that they would not be, and so what was challenged was the sentence length and the idea that their Indigenous heritage wouldn't be consideration in sentencing. It should always be a consideration in sentencing in Canada if you're Indigenous. But what happens, what was interesting with that result was the minister set aside the surrender orders. And he didn't send them back to, the judge, it was judicial review. The judge set aside the surrender orders. He didn't send them back to the minister for further consideration. So in that case, the charges, they were stayed and they basically disappeared because the judge in that case, Sharp, found that both of those individuals had suffered from the litany of disadvantages that the Supreme Court has attributed to Canadians' sorry history of discrimination and neglect in relation to Indigenous people. And I was pretty surprised at that, but that seems to have stood. Now, the last area I just want to talk about are human rights violations, because it's the second area that I found some cases on. And I think what's significant about the death penalty is that it's, and what differentiates it from other considerations around surrender is that it's a lawful penalty under international law, whereas serious mistreatment of another human being is a universal illegality. And here, Canada has sought and continues to do, in kind of a patchy way, looking at human rights around those when that's a threat. Now, abuse of process case was one, a human rights case. A man named Cotter, whose brother was in Guantanamo Bay, he was also charged with involvement in some terrorist activities. And he was living in Pakistan, but a Canadian citizen, and suspected of supplying weapons to Al-Qaeda. Now, the US wanted him, but there was no intention of laying charges. They just wanted to interrogate him. And Canada, he was released to Canada, and an extradition request was put through on these terrorism charges, but the judge wouldn't. The judge would not commit him to extradition because it was thought to be an exceptional case that undermines, that involves state misconduct, that undermines fundamental notions of justice, and there was a stay of proceedings ordered in that case. So that was very unusual. And I think, despite the fact that somebody's background and history may be problematic, the rule of law dictates that the case has to be made that justifies extradition. Another case you may be familiar with, Leonard Peltier, he calls himself, I would say Peltier, but that's not how he pronounces it. He was extradited from Canada, and that I think was a false pretense, so a human rights violation in that case. He was extradited over shootings of 2 FBI agents. There's been films and documentaries about him, so people know the case. Now, the committal hearing, the only evidence against him was perjured testimony from his former girlfriend, falsified ballistic evidence, and that became known even before he was extradited. There's evidentiary and procedural issues in his entire case, and he's been in jail almost 50 years. And despite the fact that the Attorney General who helped put him behind bars recently wrote a letter to Joe Biden saying, we made mistakes here, he's still there. Now I just want to talk about two more issues, the threat of torture and extradition to torture. In the Badashi case, again, this is a human rights issue. There was concern that there was a serious risk of mistreatment if these two individuals who had been sought for the honor killing of the daughter of one of them, and the her daughter is her mother and her uncle. She was in India and they were in Canada, and they apparently were involved in that through phoning and encouraging. And the committal ordered extradition following assurances that they would not be tortured. But if they were incarcerated, and that the courts accepted that, but ultimately there was some back and forth. But the problem is that there's no monitoring that takes place to make sure that can happen. And India doesn't have the best track record once somebody's in an Indian jail. And as far as I know, I was trying to see what had happened with that case. They were extradited in 2019, and it's going to take about 5 years apparently to get through all of the processes there. And what was kind of sad in a way was that the court determined that diplomatic assurances didn't need to eliminate the possibility of torture and mistreatment, but form a reasonable basis for the minister's findings. There was no substantial risk. Like, how can you really, what can you do once the person's out of your sight? And I think there's the reliability of assurances is questionable in a lot of different states. So the last case I want to just talk about, because it's just was decided in September, is the case of Boise versus Canada. And I think this really underlines the problem with assurances around torture. Now, Boise was a Canadian living in Mexico and was arrested for having in his possession 500 kilograms of marijuana. And he was sentenced to 14 years in a Mexican jail. And there were acts of violence and blackmail and torture committed to him even before he was jailed, committed against him, sorry. And he escaped from prison in 1999, and a guard was killed in the process. Somehow he made it from Mexico up to Quebec and was living under his own name, and Mexico found him and wanted him to be extradited, and he objected, saying there was a substantial risk of torture. He produced evidence of it and the effects that it had on him, and the minister ordered his surrender anyway with diplomatic assurances that he would not be tortured. Well, I mean that, and 2 days prior to his extradition, they found he was going back to the same jail where the guard had been killed. He went back, and actually in 2011, the UN Committee Against Torture determined that Canada had violated the Convention Against Torture by extraditing him because he was tortured. He was finally released in 2018, and at that point, no action had been taken, but he decided to sue the federal government for breach of his rights, and he was awarded $500,000 in damages. And this is considered to be the first decision where a court has awarded damages for Canadian complicity in torture abroad. I don't know, and I think what the Judge Campbell, he describes it as the willfulness of the infringement, because the federal officials acted with full knowledge of their situation and the likely consequences. So I'm going to skip that last one. Just go to my conclusions. I think that clearly there are tensions between state interests in combating transnational crime to facilitate extradition, but at the same time, the role of human rights should occupy a more significant place. I think for me, and from my wrongful conviction background, I read these cases and I feel, not in all of them, because some of them have better outcomes than others, there's a sense of injustice around what happens, and that it takes, so the need to combat crime takes a backseat to international cooperation. And I think really just this brief overview of the process and a number of cases for me raises a lot of troubling questions about our Extradition Act and how extradition proceedings are undertaken that demand reform. And I just heard yesterday from, yesterday from Hassan Diab's lawyer that the the UN, the House of Commons is starting a committee looking at the Extradition Act. So something may be coming down the pipe. So anyway, thank you very much.
Thank you very much. Well,